and otherwise bond is continued.
Will I get a reminder?
Mr. Myers, I'll make sure you're aware of the court date.
Okay, thanks, buddy. Appreciate it.
I was talking.
I apologize.
Anything, Ms. Rudder?
I'm sorry, Your Honor. So for Ms. Jacqueline O'Brien, Your Honor, Ms. Gray said she's going to look into her traffic warrants, but the case she has right now, actually the warrant is lifted. So they should not be holding her in for your cases.
Listen, it's some things I know, but so the warrant is lifted, but so is it already a personal bond?
No, it just looks like someone has set aside her warrant. Ms. Gray said, again, she is going to look into it. She says she does have several traffic warrants. That may be why they're holding her, but they look to be personal bonds. She says she's going to look into that because she said there are a lot of traffic and ordinance violation warrants. But for your case, actually the warrant has already been lifted. So your case is not holding her in.
The warrant is lifted, but she still has a $500 10% bond.
Yes.
All right. So that's the situation, counsel, with respect to the bond. So here's the thing. If someone tells me they have the bond to post, which I believe everybody should have $50, but that's besides the point. If somebody says, this is a mess, I need y'all to tell the people in the breakout room, when they come out of the breakout room, one, I don't know why they're unmuting, but two, the rule of being stationary, seated in the upright position, ready to attend court is applicable. Don't come out of the breakout room walking around and it's distracting to what is going on in the courtroom. All right, I'm going to put Miss Almond in the waiting room. That was very distracting. Okay, she has a $500 10% bond on my case. And nobody is stopping whoever she claims is trying to come down and post that bond. Nobody's stopping them from posting the bond. Now, if somebody tell me they can't afford the bond, which I think they should be able to afford the bond, then I'll address that. But Ms. O'Brien says not only can she afford the bond, she has sent someone to post the bond. Now, perhaps the person that she sent to post a bond is the one that's not being honest with her about where the $50 is going. But she can post that $50 bond. And she has numerous of other warrants, which could be what's holding her in the Macomb County Jail. Now, I don't know. So we can wait and see. But I mean, my case is pretty much over. The $500 10% bond is affordable. She can afford it. And she can tell the person who's supposed to be coming down here to stop taking her $50 and go ahead and put it on the bond. We are receiving bonds. We are receiving bonds. We are receiving payments for bonds. This case, the bond can be paid by coming down to 36th District Court, standing in the line at the bond window, and handing them $50 in cash or $50 on a credit card. Anything further?
No, thank you, Judge. No, thank you, Your Honor.
All right, then we're all set until August the 2nd.
Judge, if I may.
You may. Sure, Mr. Murad.
Sorry, Ryan Murad, PA 3665, also appearing on behalf of Miss O'Brien. Your Honor, I don't know what's going on with her and whoever she's asking to pay this $50. And I'm scared because she hasn't been employed and because she's been in there for quite some time, that if this person isn't reliable and they haven't been reliable in the past, I'm not so sure they're going to be reliable in the future. And I don't think she personally can afford it, Judge. I think that somebody close to her is telling her that they can. But because of that, because rehab is really depending on this, I don't want to put it in someone else's hands, Your Honor. I'd rather have it in ours. And for that reason, Judge, I'm going to ask the court to consider reducing bond to personal. Now, she did miss court. She did have some issues, but because she's being proactive and she's going to be getting into rehab, I think she's getting played, to be quite honest with you, Your Honor. I think somebody is lying. And
she don't realize she being played, because let me tell you this, she was real adamant with that deputy. Remember when I told her to stop talking? She was acting like we doing something wrong. I've been trying to pay the bond. I've been trying to pay the bond since, as opposed to saying, I don't know what's going on. So look at the difference. I don't know what's going on. I have sent someone to pay the bond, and they are telling me that they're not being allowed to pay the bond. Can somebody look into it? As opposed to, I've been trying to pay the bond. I've been trying to pay $50. They won't take the $50. I've been trying to pay the bond for 4 weeks. And for 4 weeks, 36th District Court has been saying, no, we don't want no $50. Even though the judge set the bond at $50, 510%, we don't want it. Well, this is a lesson for Miss O'Brien. This is a lesson for Miss O'Brien. One, that when you come before the court, you might, I'm just saying, it's just me. You might want to show some humility. That's number one. Number two, that's why we appoint lawyers to people. That's why we say lawyers should be the ones representing. So perhaps if she had to just let Mr. D'Amico, did I pronounce your name all the way wrong?
D'Amico, but that's okay.
Yes,
thank
D'Amico.
you.
I knew when I said it, because I was like, that's not a, yeah, okay.
That's okay, thanks.
Listen, if she had let Mr. D'Amico speak, I wouldn't even knew she had that attitude. I wouldn't have even known that she was blaming 36th District Court for her being locked up. I wouldn't even know. But since she was not letting her lawyer speak for her, and her whole attitude just blossomed. It just was like, y'all don't know what y'all doing down there. I keep trying to pay the bond. And they won't take the $50. They won't even take the $50. We taking everybody else $50, $10. And people come down here, they post their little $10 bond. We take their $10. But for some reason unknown to us today, they would not take Miss O'Brien's $50. Yes, counsel?
I just believe it might be just a little bit of a built-up frustration. I know it's, it shouldn't be that way, but I think if she's just frustrated, she just wants to, attend the rehab. And I think there's just something going on there. It's unfortunate, but if we can just, play the field here and just, move on with this so she can attend the rehab, that would be great for her. I think she's just has a little bit of frustration here. I do apologize.
This is what I'm going to do. I don't know what's going on with all of those, a whole bunch of traffic warrants that she has out there. Miss O'Brien is charged with retail fraud. And I'm going to let her get out of jail to go to the rehab, but she's going to be tethered to the rehab because there's some things that I also know. Some things that I also know, having been practicing law and being on this bench for 16 years. There's some things that I also know. And I would, if I was in jail, I would be trying to get to the rehab too. I would be trying to get to the rehab because right now I'm in jail. So of course I'm going to tell the people I want to go to rehab, because where I don't want to be is this jail. I'm going to reduce her bond to $500 personal bond plus a GPS tether, and she will be tethered to the rehab. So wherever they sending her for rehab, that's where she's going to be tethered to. A restricted GPS tether. She's tethered to the rehab. Anything further?
No, Your Honor. Thank you very much.
All right. Did we know what rehab she's going to?
I do not, Your Honor. I will find that out.
So what we need to know is whatever her other bond is that's sending her to rehab, this bond is sending her to that same rehab on tether. Okay.
Okay.
Would you like us to get her in the breakout room and get that information so the court has it?
Yeah, sure. If it's available, Mr. Murad, if that information is available, I want you to get it.
I'm going to get it, Judge. We're going to put her in the breakout room now, if that's okay.
Yes, you may.
Thank you, Your Honor.
You're welcome.
Thank you, Your Honor.
You're welcome. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You may put your hand down. Ms. Stevenson. Ms. Stevenson, you're muted.
Thank you, Your Honor. I apologize to the court. Mr. Elamine, on June 11th of 2022, were you present in the area of 2028 Lafayette Street in the city of Detroit?
Yes.
And did you there fire one shot into the air with other people present?
Yes.
Thank you. With that, Your Honor, defense is satisfied.
Are the people satisfied? Are the people satisfied?
Judge, the people just would like to establish, for purposes of the record, that Mr. Elamine shot that firearm in the air without due caution or care for the right, safety, and properties of others.
We stipulate to that.
Is that something that can be stipulated to?
So
when he shot the shot up in the air, did he use due caution and care or whatever for the safety of others?
Yeah, I mean, I indicated that other people were present, but if that's not satisfactory.
Sir, were you trying to make sure that you wasn't shooting the people that was present, or what did you do when you shot that gun up in the air?
I shot it in the air. I didn't aim it at anyone or anything.
And did you put a bubble around the people so that you could make sure that when the bullet came down, it wasn't going to hit anybody?
I'm not understanding your question, Your Honor.
Yeah. When you shot it up in the air, did you make sure that when the bullet came down, that it wasn't going to hit anybody? Did you put a bubble around the people to make sure that it wasn't going to hit anybody?
I don't believe that that's possible, Your Honor.
So then that means you didn't do it, correct?
Because it's not possible. That is correct.
Does it mean that you didn't do it? Because in a minute, I'm not going to accept the plea. So he either can argue back and forth with me, or he can tell me if he put a bubble around the people so that he can make sure that they didn't get hit. Now, that's the question I'm asking. And if that's the answer he's given, then I'm not going to accept the plea.
So Mr. Elamine, answer to that question is yes or no?
No, I did not put a bubble around the people.
Thank you, because it was a yes or no question. Are the people satisfied?
Because the people are now satisfied.
The court is also satisfied. I will accept a guilty plea to one count of attempt reckless use of a firearm. Having accepted the guilty plea, the court is going to set the matter for sentencing. I'm going to set the sentencing for Friday, July the 21st. At 9:00 a.m. With respect to the sentencing, you have a right to be sentenced in person, and you may consent to being sentenced on Zoom. Which do you prefer?
Zoom is fine.
The court is going to set the matter for 9 a.m. on Zoom. I am going to send Mr. Elamine for a pre-sentence investigation and substance abuse evaluation through the probation department. Sir, they are going to contact you by telephone. If they cannot reach you, they will mail you a letter and leave you a message directing you to contact them at a particular day and time. Please make sure that you respond to their phone call or their letter so that I may have a proper pre-sentence investigation on the date of your sentencing.
I understand.
Anything further with respect to Mr. Elamine?
Not from the people, Judge. Thank you.
Nothing on behalf of Mr. Elamine. Thank you very much, Your Honor. Thank you to the people for the reduction in the charge.
All right. And then
state your full name for the record for us.
Tyran Anthony Jonas Mason.
All right, your parents was like me, Mr. Mason. They gave you 4 names. That's the same thing I did for both of my kids for no reason, but just because we feel like it. Okay. Today is the date set for review. And let's see, Mr. Mason, according to Ms. McCall, has a big, huge, gigantic traffic balance that he is paying $200 a month on. We don't have verification yet of the community service. He does have one of them weed cards that no one has ever been denied. If somebody has been denied a marijuana card and you watching on YouTube, just inbox me. I just want to know if they are denying anybody. Like my fingernail broke down too far. I need a marijuana card. Oh yeah, sure. Okay. Anyway, he has paid his assessed fines, costs, and fees. He has provided verification of the participating with Detroit at Work. He has an upcoming appointment for the outpatient treatment. His GED program begins August 25th, but there was no verification. One thing that is missing and that I don't have, because I don't have the file that I created for Mr. Mason, when did I place Mr. Mason on probation?
I believe it was April of 2022, Your Honor.
And so?
For an 18-month probation.
Oh, 18 month, okay.
His final discharge date is set for October 4th, 2023.
Okay, and he's been negative for all prohibited substances. He's been negative for all prohibited substances. So it looks like he needs to give us proof of his enrollment in the GED, and then he's going to, he has an appointment for the outpatient treatment. He's kind of slow with that because he should have been in that treatment.
He was, Judge. I don't know what happened, but he had to re-enroll.
Oh, okay.
So he was doing that in the beginning, but he did re-enroll. A brief update on his community service. He's got 30 out of 40 hours done. Ultimately, Judge, I'm just going to ask the court to continue this to his final discharge date. I'm pretty confident Mr. Mason's going to have this knocked out of the park by then.
Are you confident, Mr. Mason, that you're going to have it knocked out of the park by October?
Yes, ma'am.
Okay. Ms. Rutter, what's his final review date on there?
She'll kill you. Go too low.
Mr. Mason, who they say they gonna kill you? What's it? You might need to move. You muted, but you might need to move. They don't sound friendly. You might need to move because we don't want to see you. I mean,
He's moving.
Did y'all hear? I mean, I'm the only one that heard them. Okay. He needs to go to safety. When is his date so we can let him go? Because they weren't happy.
October the 4th, Your Honor.
All right, October 4th. We're going to move him to October 5th at 1:30. All right. I hope that's your final review date, October 5th, 1:30. And don't go wherever you are right now because they're not happy. They're not happy. Don't go there. Okay. Anything further?
Nothing further, Your Honor.
All right, then we're all set. Mr. Mason, you have a great day and stay safe.
Rachel McDuffie for the people.
And Assistant Public Defender Chinazi Carey, I can really on behalf of Mr. Jermaine Wilson. Mr. Wilson, can you state your name for the record, please?
Jermaine Wilson.
Thank you, Mr. Wilson. We're here for an adjourned pretrial in this matter.
That is correct, Your Honor. We've spoken with Mr. Wilson. He would like to set this matter for a final settlement conference.
Well, we can't do that. This is another case where I believe, hold on, let me just check. I believe
put on the record last time that this was a felony DV third and that you'd be dismissing and reauthorizing. They did not accept the plea.
Correct, Your Honor. So yes, there's a bond violation as well, but that may only be relevant for the next 2 minutes. So if that is indeed what Mr. Wilson understands and agrees to, that he's going to be charged with a felony, we can't resolve this case in this court.
Is that curiosity?
1 second, Your Honor.
I'm Jermaine Wilson.
Yes, sir. We know you're Jermaine Wilson. Are you listening to what the prosecutor is saying about your case?
Yeah, I don't know if it's y'all volume or mine, because I just had y'all up and I heard y'all. And then next thing you know, I can't hear y'all now. My volume is all the way up.
Can you hear me now, sir?
Yes, I can hear you.
So what she's saying to you is if you're not taking the offer today, she's dismissing this case and charging it as a felony. You understand that, sir?
Charging me a felony for what?
Judge, we did not have that in our notes. We did not discuss that with Mr. Wilson. I do apologize. And Ms. McDuffie, that's only if he doesn't take the offer, or is that are you reauthorizing it?
Well, so Mr. Carey, I can really, it's essentially these priors they're a little bit older, so they got missed when this case was charged. So the correct charge, this is the DV. I forget this charge is the first or second, but there are 2 priors which would make it a felony third. When that happens, what I tend to do is just say I can make the offer that they would plead to the misdemeanor instead of immediately reauthorizing it, to give them an opportunity to have a reduced charge. So it's fine for him to reject that, but if he does, the correct complaint can't be handled in this courtroom because it's a felony. So I would have to dismiss and reauthorize it. So if you haven't had an opportunity to fully discuss that with him, I understand that. We can adjourn if the judge will allow it. I don't have any objection to that.
Judge, we would need to let him know that. I do apologize. So we'd be asking for a brief adjournment.
July 17th, 2023 at 9 a.m.
What's that date again, ma'am?
July 17th, sir. 2 weeks from today.
Oh, July 17th?
Correct.
At what time again?
At 9 a.m., sir.
Okay.
Your bond is continued.
We do have a violation, Your Honor.
What violation is that?
Your violation for the bond. There's a bond violation, sir, in that you were supposed to be testing and you failed to report for the last 3 tests, June 5th, June 16th.
I missed them 3. I talked to my the lady at Community Corrections because I got a job. I work from 5:30 in the morning to 4 in the evening. And then when I started that job, I had told the lady I called my number, and she said, well, you got to come in before your court. When I called her, it was time for me to come in to test. I told her I ain't got no problem testing. I haven't dropped no dirties. They never called me to say I dropped the dirty. I've been complying with them.
As I was saying before, I was rudely interrupted, sir. You are being charged.
Say that again. I can't hear you.
Sir, you're being charged with violating the terms of your bond in that you missed 3 tests, June 5th, June 16th, June 22nd. You're entitled to have a hearing in that matter, at which time, if it is found that you violate the terms of your bond, or if you admit to violating the terms of your bond, you could be subjected to have your bond revoked. Do you understand that, sir?
Yes, I do. And the lady, but she told me that when I was in there, she said, as long as you won't come in and drop for anything else.
Sir, stop. First of all, I'm the judge. I make that decision about whether or not you're violating.
Yes, ma'am. Yes, ma'am.
Do you understand that?
Yes, ma'am.
All right. Secondly, I'm going to let you speak to your attorney so you can figure out what you would like to do at this point. Okay?
Okay.
All right.